Well, tonight, all this is getting even more complex, if you can believe it. The Fulton County Commissioner now launching an investigation into allegations that Willis misused county funds and took gifts or other personal benefits from Wade. Now, there are potentially huge implications here. Will Willis or Wade lose their jobs? Who would replace them if that were the case? And is the case itself in jeopardy? And frankly, what does this mean for Trump and the other co-defendants? I mean, it may not take too long for us to learn the answers because the judge overseeing this important Georgia case has now set a February 15th hearing to consider whether Willis and Wade should be disqualified. I want to dig right into this because this is such an important conversation with former Trump attorney Tim Perlatore, trial and compliance attorney Seth Berenzweig, and Tia Mitchell, Washington correspondent for the Atlanta Journal-Constitution. Okay, just going through what I've described, messy, reads a bit like a Housewives episode of some kind, and yet all of that's going on is deeply interesting for so many reasons because it could actually mean that this very important trial in Georgia will be viewed through a lens that they don't intend it to be. Let me begin with you here, Tim, on this issue because, look, we don't yet know what her response is to the allegation. She has not directly addressed them. But when you hear this at first blush, what do you think of? Is this really tied to the facts of the case or really about a soap opera?
You know, it doesn't really have any bearing on the specific allegations in the case, and they haven't really tied it to impropriety in bringing the indictment. So I think that, you know, whenever you bring a prosecutorial misconduct motion, I've done these before, and you ask for dismissal, you ask for disqualification, and in a case like this, I see disqualification being a very strong argument, dismissal not so much, because ultimately, this misconduct, if proven, which sounds like it's going to be conceded in some ways.
Maybe, we don't know that.
It is something that ends up putting their personal interests tied to the case. And so therefore, judges do frequently disqualify. I've had that myself in previous cases. And so they would be out. The Fulton County District Attorney's Office would be out because she's the head of that office. And another office would come in, possibly the Attorney General or another county, which could take a very different view of the case.
Well, let me ask you, when you think about this, and if it's not implicating the underlying facts of the case, is it that the optics don't look good and therefore a jury pool might raise an eyebrow? Because you have to wonder if these allegations don't actually go to the heart of the matter. And we're not really clear entirely how they do, although the disqualification request suggests that judgment is impaired here in some respects. What is the issue?
Well, the issue at hand is whether this co-defendant in the RICO case can use the dirty laundry from this incredibly messy and high-level divorce to soil the RICO case in a way for him to tell the court that this is such an infected, corrupt process that they should be thrown out and this case should be thrown out and everything should be turned upside down. And while I absolutely agree that in the court of public opinion, this is really a hot mess, and I don't even know what she was thinking. Her brief on this issue is due February 2nd, so we have to wait a little bit in terms of reserving that judgment, hearing on February 15th. But regardless of what happens in the court of public opinion, I really think that in a court of law, it's going to be very difficult for this co-defendant to say that this messy laundry in a divorce case is something that can disqualify these folks or certainly to have his case dismissed in the RICO action.
You know, it's interesting. There's an irony I can't get out of my head. The idea of so many people have been angered about a lack of due process when it relates to Donald Trump or any of the co-defendants. The assumption that there's some political witch hunt that's underlying all of it, and you have to give them due process and the benefit of the doubt. And there's an eagerness, right, in our society to get all the answers immediately, and we try to bypass that at times because we want the answers now, and she has said, I'll let my filings speak for it. But there is something about the jury pool, and I always go there as a trial attorney and think to myself, what do I want the jury to be thinking about when I'm standing before them? What message do I want to send? How do I want their minds to be focused? And you have to wonder about how this will play for a jury to look and see, is this person here fairly? Are they qualified or something else? Does it cast some doubt on it? And is that worth it?
As a prosecutor, you really want to be able to have, a higher moral position. And
Morality for lawyers. This is a new course to teach. I don't know, but okay.
I know, but it is one of those things where, especially if you're going to bring a case of this magnitude, you have to hold the high moral ground. And when you cede that, assuming that these allegations are proven, I think it will significantly impact, her credibility. As far as, for example, Nathan Wade, I mean, he's kind of a different story here. I dealt with him very briefly. Took me 20 seconds to realize that he was not competent to handle this case.
Why do you say that?
Just, he doesn't understand basic criminal principles.
I'm sure he would take issue with that, right? Obviously, you're connected as a counsel, so I don't know his personally his work.
He didn't understand the Fifth Amendment is something that operates for witnesses to invoke when they are accused of being a conspirator. So, simple things like that he didn't understand, and that he can get a judge to just simply order it.
So you're championing a bit on that. Excuse me. Go ahead.
Well, be careful what you wish for. I mean, there have been allegations that he's a lightweight. But if you're a criminal defendant, I don't know why you'd want to disqualify him. Now, in fairness to him, he has also been a judge, and there have been elements of his resume that balance in the other direction. So, reasonable people can differ. But really, this has become a weapon of mass distraction for Mr. Trump and the co-defendants. It's also going to be an open question as to whether this will ultimately get to the jury, because they will absolutely file a motion to preclude this admission, to say that it's not probative, it's prejudicial, it's very, very distractive. So it's very much an open question about whether it comes in. But I think we're all in agreement that this is an incredibly bad look. We'll see what she files on February 2nd, but it really raises a heightened degree of concern.
We've all talked about the discussion about those who are elected prosecutors and those who are not, and how this can really muddy the waters for a lot of reasons. Really fascinating. Thank you both. Of course, double-edged sword. If she were to go in and you think, well, we think the lady doth protest too much. A little bit of Shakespeare on Friday night. Thank you, guys.